Hello, my students. Today's discussion is National and International Obligation of India under the Directive Principles of State Policy. To start with, the Directive Principles of State Policy, which is found enacted in the Part 4 of the Constitution of India, impose obligations on the states. It has been declared that the state shall strive to promote the welfare of the people by securing and protecting as effectively as it may a social order in which justice, social, economic and political shall inform all the institutions of the national life. Further, the state shall in particular strive to minimize the inequalities in income and endeavor to eliminate inequalities in status, facilities and opportunities, not only amongst individuals but also amongst groups of the people residing in different areas and engaged in different vocations. On the basis of the obligations that are imposed in these principles, classifications can be made as: first, certain ideals, particularly economic, which according to the framers of the Constitution, the state should strive for. Secondly, certain directions to the legislature and executive, which are intended to show as to in what manner the state should exercise their legislative and executive powers. And thirdly, certain rights of the citizens which shall not be enforceable by the courts like the fundamental rights, but the state shall nevertheless aim at securing by legislative and administrative policy. So this study shall center around the aspect of the national and international obligation of India under these policies by making an analysis of the directive principles as laid down in Part 4. So as far as the national obligation is concerned, as regards the national obligation, Article 39B and C of the Constitution are very significant provisions as they affect the entire economic system in India. Article 39B contemplates measures to secure equitable distribution of community resources. Article 39C contemplates measures for preventing concentration of the wealth and means of production in a few private hands. Article 39B and C do not merely have reference to acquisition of the land, but their objective is to prevent concentration of the wealth in any one individual. Concentration of the large blocks of the land in the hands of a few individuals is contrary to the Articles 39B and C. The other provisions under Article 39 are the rights of the citizens to adequate means of livelihood, equal pay for equal work for both men and women, rule against forced labor, and rule against child abuse and neglect. Under Article 39A, the national obligation of India is the requirement of providing free legal aid to the deserving people so that justice is not denied to anyone merely because of economic disability. The obligation of the state is to secure that the operation of the legal system promotes justice on the basis of equal opportunity and shall in particular provide free legal aid by suitable legislation or schemes or in any other way to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities. In implementation of this obligation, the Parliament of India has passed the Legal Services Authorities Act 1987, under which any citizen can avail of the opportunity of free legal aid and advice under certain conditions, and also to the eligible persons is defined in the Act itself. The obligation to organize village panchayat is enacted in the Article 40. The state is to take steps to organize village panchayats and to confer on them necessary powers and authority to enable them to function as the units of self-government. The idea underlying this constitutional obligation is to introduce democracy at the grassroots level. In implementation of this obligation, the Parliament brought out Constitution 73rd Amendment Act 1992, incorporating the provisions of panchayats and made detailed provisions for functioning panchayats in the Indian villages. As regards the national obligation of doing social services, Article 41 requires the state, within the limits of its economic capacity and development, to make effective provisions for securing right to work, to education, and to public assistance in the case of unemployment, all as sickness and disablement, and in other case of undeserved want. In giving effect to this obligation, the Parliament has passed the law known as the Maintenance and Welfare of Parents and Senior Citizens Act 2007. The rights to work is one of the basic human rights in the socialist society like India. This follows from the goal of the socialism, from the significance which is attached to the work under the socialism, and from the position of the individual citizens in socialist society. The national obligation of India in this regard is that the entire process of the social development depends on work and its results. Thus, right to work reflects the relationship between society and the individual and is a source of people's social optimism, which is to be promoted in fulfillment of this obligation. Next, Article 42, which provides the basis of the large body of the labor laws that obtains in India. Labor welfare is another national obligation of India. Under this article, the state is to make provisions for securing just and humane condition of work and for maternity relief. Further, the obligation to provide living wage to the workers is laid down in Article 43, enunciating the revolutionary doctrine that employees are entitled as of right to certain reliefs of living wage to ensure decent standard of life. In particular, the state is to promote cottage industries on an individual or cooperative basis in rural areas. Another dimension of the obligation is laid down in Article 43A, to take by suitable legislation or in any other way to secure the participation of the workers in management or undertakings, establishments or other organizations engaged in any industry. India is to emerge as a much more cohesive and integrated nation when a uniform civil code for whole of India is brought about. The obligation is cast under the Article 44. This is mostly referred to personal laws applicable to different groups with uneven contents. With the enactment of a uniform civil code, secularism will be strengthened. Much of the present day separation and divisiveness between the religious groups in the country will disappear. The provision of free and compulsory education is another obligation which India has to discharge. Article 45 requires the state to endeavor to provide free and compulsory education for all children until they complete the age of 14 years. In giving effect to this directive, the Parliament of India has enacted the law known as the Right of the Children to Free and Compulsory Education Act 2009. Further, this right of the children is made a fundamental right in Article 21A of the Constitution for the children of the age of 6 to 14 years, making a further obligation to the state to provide early childhood care of the children up to the age of 6 years. We come to Article 46, which obligates the state to promote with special care the educational and economic interests of the weaker sections of the people, and in particular the scheduled castes and scheduled tribes, and to protect them from all forms of exploitation. Another obligation as one of the primary duties of the state is enacted in Article 47. The duty is to raise the level of nutrition and the standard of living of Indians, and also to improve public health. In particular, the state is to endeavor to bring about prohibition of the consumption except for medicinal purposes of intoxicating drinks and drugs which are injurious to health. The obligation to organize animal husbandry and agriculture on modern and scientific lines, and in particular to take steps for preserving and improving the breeds and prohibiting slaughter of the cows and calves and other mills and draught cattle is enacted in Article 48. A number of the states in India have enacted laws to preserve, protect and improve livestock. The validity of some of these laws has been in question before the Supreme Court, where the court upheld the laws and interpreted a harmonious construction of giving effect of directives, as well as the fundamental rights of a section of the citizen to carry on trade and profession. It has been a national obligation of India under Article 48 of the Constitution to implement ban on cow slaughter. The obligation is imposed with the objective to ensure the public to have a sufficient supply of the milk, and further to ensure to people to have a sufficient number of draught cattle for agricultural operation. The obligation to ensure protection of the wildlife is also not the least obligation, considering the importance of the public health by ensuring environment protection. Article 48A obligates the state to endeavor to protect and improve the environment, to safeguard the forests and wildlife of the country. Not only an obligation of the states as envisaged under the article, there is at present a growing consciousness and awareness that suitable measures be adopted to protect the environment, forests and wildlife. To enable the national obligation to discharge unrestrained, the subject wildlife and the forest have been placed in the concurrent list in the 7th schedule, and central government can play a significant role in this area of the protection of wildlife. The Environment Protection Act 1986 is a law passed by the Parliament in giving effect to this directive. Now we come to the protection of monuments, which is another important national obligation which India must discharge. Article 49 directs the state to protect every monument or place or objects of artistic and historical interest which are declared by or under the law made by the Parliament to be of national importance, from spoliation, disfigurement, removal, disposal or export, as the case may be. The aspect of separation of judiciary from executive is another obligation which the state must bring about. The separation of judiciary from executive is regarded as a very necessary element for proper administration of justice in the country. Article 50 enjoins such a duty, and by and large this goal has been achieved in India. These are the various national obligations of India as mandated by the directive principles of state policy under the Constitution. In discharging the various obligations, the Union of India as well as various states have taken up legislative measures. Now we come to the international obligation. The directive principles of state policy envisages international obligation for India is laid down in Article 51. Under that article, the state shall endeavor to, number 1, promote international peace and security. Secondly, maintain just and honorable relations between nations. Thirdly, foster respect for international law and treaty obligation in the dealings of organized peoples with one another. And fourthly, encourage settlement of international disputes by arbitration. As regards the position of the international obligation as enacted in Article 51, it is to be noted that national legislation, even though contrary to any international law, has to be respected for the reason that international treaties do not automatically become the part of national law. They have to be incorporated into the legal system by appropriate law. For example, the Geneva Conventions of 1949 have been incorporated by a legislation known as Geneva Conventions Act 1960 by the Parliament of India. And the conventions became a law of India since the year 1960. So it is pertinent to mention to the Article 253 of the Constitution that the Parliament has power to make any law for the whole or any part of the territory of India for implementing any treaty, agreement or convention with any other country or countries, or any decision made at any international conference, association or other body. However, even though international law has not been enacted as an Indian law, national courts generally interpret statutes so as to maintain harmony with the rules of international law, and in such cases when the international law rule does not conflict with the national law. The constitutional provisions embodied in Article 51 are the principles which the Indian foreign policy is to follow. So far as the question of legal effect of a treaty entered into by India with a foreign country is concerned, till the same is enacted by the Parliament under Article 253, the same will not be counted as a law, as Article 51, Clause C does not deal with enforcement or implementation of treaties automatically. Even if an international law rule has not become an enacted law of India, the Indian Supreme Court referred to the international law rule to solve the problem in India. So now we come to the conclusion. The Constitution of India included socio-economic rights such as the right to primary education, the right to educate means of livelihood, or the right to work in the Part 4 of the Constitution. These social and economic rights have been recognized in the Universal Declaration of Human Rights and International Covenant on Economic, Social and Cultural Rights. The Supreme Court of India, as early as in the year 1993, declared the right to education, the right to shelter, and right to childhood as being part of the fundamental right to life and personal liberty guaranteed by Article 21 of the Constitution. In the celebrated Unni Krishnan's case, though certain national and international obligations are laid down in the Part 4 of the Constitution, these directive principles are in the nature of instructions to the government of the time to do certain things and to achieve certain ends by their actions. The directives are, however, required to be implemented by legislation, and so long as there is no law carrying out the policy laid down in the directive, neither any individual or any state can take up the action for enforcement in any courts. No justiciable right in favor of an individual is created. These obligations are not enforceable in the court, and no court can direct the state to discharge the obligation. But referring to Article 355, which casts a duty on the Union to ensure that government of every state is carried out in accordance with the provisions of the Constitution, it should be the duty of the Union to see that every state takes steps for implementing the directives as far as possible, like to prevent the slaughter of the cows, calves, and other milch and draught cattle, or to introduce prohibition of consumption of alcoholic drinks, and so on. So friends, with these few words, let us conclude for today. Have a good day.